Hi everyone, hope you're well. So there's a myth that writing a will is a preserve of the wealthy, which can't be further from the truth. There's also a myth that if you're writing your will, you're contemplating your death, or you will hasten your death, again, which can't be further from the truth. As long as you're above 18 years old, you own a property or two, you have maybe bank accounts and insurance policies, and you have children and beneficiaries, maybe grandchildren, then you qualify to write a will. A will is a very, very important document that saves families a lot of conflict, hassles and tussles around property. So I encourage you to write a will. Today I want to go through, my name is Wakili Kiti, I'm an advocate of the High Court, and today I want to go through the process of will writing. So what is a will? A will is a legal document that documents the wishes of a testator. A testator is the person who writes the will. So before you die, before your demise, if you've written a will, you're called in law a testator. So a will is a document that documents the wishes of a testator surrounding his property and how his property will be dealt with. But not necessarily just property. He can express or pronounce himself or his wishes on other things surrounding his person. All right? Like children, you can appoint a guardian ad litem. You can express your wishes on how you want your body to be disposed of, etc., etc. And on that line, let me talk about the advantages of writing a will. So, an advantage of writing a will is you will have an opportunity, one, to disclose all the property that you own. There are people who die having left a lot of property unknown. People have monies in bank accounts, offshore accounts. People have bank accounts that are not even known to family members. People have title deeds and property but stashed in the roofs of houses and nobody knows about them. But if you decide to write a will, then you have an opportunity to document all that you own, so much that when you die, the property does not fall in the hands of people that will take advantage or in the hands of people that will not benefit from your property. So that's a very, very important reason why you should consider writing a will. Writing a will also gives you the opportunity to appoint a particular person that you're confident will be able to administer your estate when you're gone. If you do not appoint an executor to your will, if you do not appoint an executor through a will and you die intestate, dying intestate means you die without leaving a will, then the state or the laws will determine who becomes the administrator of your estate. And maybe they are not the best people, or maybe they're not the best person that you wanted to administer your estate. A will also gives you the opportunity to determine which property goes to which beneficiary. You could have children who are in different stages of life, and through a will you can then select which child gets what, where, how much, etc. And so you have an opportunity to have an equitable distribution. But if you do not write a will, then it ends up to the state, and then the state decides who gets what and what. Having a will gives you an opportunity to appoint who becomes the guardian to your children. Sometimes you die with children who are minors, and you can appoint that this particular person becomes the guardian to my children. But if you do not have a will, then again, it goes to the state. The will prevents conflict because this is your property, and nobody has higher rights to your property than yourself. So by you writing a will, then you expressing unequivocally how you want to deal with your property, and people are going to respect that. So wills prevent a lot of conflict. Okay, so those are the advantages of writing a will. I want us to discuss the two types of wills. There is an oral will, which is, again, as the name suggests, it's oral, it's verbal, and there is a written will. As a lawyer, I will not recommend anyone to give an oral will because of the challenges of proving it and because of the challenges of of how easily it can be disputed. Nonetheless, I will discuss what an oral will is and what legal formalities have to be achieved for it to be valid. An oral will must have been made in the presence of two competent witnesses, and the testator or the person making the will must die within 3 months. So if you make a will before two competent witnesses but you die after 4 months, 5 months, 6 months, that will becomes invalid. And even if you made a will between two competent witnesses and you die in 3 months, but the two witnesses have different accounts of what you made in your will, then that will be challenged and will be invalid, not unless there is a third independent witness who witnessed the making of that will. So again, as I said, there are challenges around oral wills. As a lawyer, I would not advise anyone to make oral wills. The second type of a will, which is the recommended will, is the written will. So a written will is documented. There's documentary proof to that effect. All right. The formalities that are required for this will to be valid is: one, it must have been executed by the testator. All right. And two, it must have been witnessed by two competent witnesses. So these witnesses must witness the execution by the testator, and they must in law do something called attest. So attesting basically is saying we saw this guy sign this will document, and then you also append your signature as a witness. If one of the witnesses is a beneficiary in the will, for instance, one of the person witnessing amepatiwa mali kwa will, then there's need for another set of two witnesses to witness the execution of that will. This basically is just safeguards that the law has put in place to avoid a situation where people take advantage, instigate the writing of the will, and do influence the distribution of the property, and then other people end up getting prejudiced. So those are the formalities surrounding a will. Some of the requirements for also a will to be valid are: one, that the testator needs to have capacity. You need to be above 18, and you need to have the mental capacity. In law, we call it the testamentary. Testamentary capacity is the all-inclusive name for this testator having capacity. So your age must be right, and your mind frame must be right. The mind frame is you need to appreciate. You need to be in a mind frame that knows or appreciates the extent of properties that you own. You need to be in a mindset that acknowledges appreciates the extent of beneficiaries that you need to bequeath your estate to. And you need to appreciate your moral obligation to provide for your dependents and family. And lastly, you need to appreciate the nature of making the will and the legal effect that making the will has. So if you are not in that mind frame, maybe uko na ugonjwa ambao unakufanya you don't appreciate, or you're insane, or you're unstable in a certain way, then that capacity might be challenged. Secondly, you need to have the knowledge, and you need to have knowledge of what the will entails. So it's not just a document to present you a sign up. No. You need to have the knowledge of what it entails in the will, and you must approve. Now the approval comes with the execution. So once you know the contents of the will, then you end up approving it. So as I said, this is not a preserve of the wealthy. Anyone can write a will, and you might be there wondering, but why am I writing a will? I'm only 18 years old. I have all these so many years to live. Well, you could have all so many years to live, but again, you could not have. So it's life. That's how life is. You don't know when you're going to die, and that's why it's important to write a will right now. So you could also be wondering, then why would I write a will right now, and then after 10 years I'm in a different level altogether, and this will becomes a null and void. In law, there's a document called a codicil. A codicil is like a will, but it's an addition. It's an addition to the will. So every time you make a milestone, say you get married, or you get a new child, or you get a grandchild, or you buy a material asset, or you gain another intellectual property asset, and you could always update your will through this codicil and have it stored. Okay, and that's now where we came in. That's now where as Law 254 come in. We come in to help you draft the will, or if it's drafted, we come to help you understand or appreciate or checklist if that will is valid, so that it's not challenged down the road. We help you in updating wills through codicils. So maybe you made your will 10 years ago, but now the things that you need to update, that's where we come in. We help you with the storage of wills, because wills, again, ought to be stored in a safe place, and a few people who are beneficiaries notified that, hey, Law 254 or Wakili Kitty is the one who has our will. So in case anything happens, we can always pay reference to him and he'll give us the contents of the will. So that's what we do. I'd also want to share a little bit more of what I've experienced during my stint in this legal terrain around wills. Wills get challenged a lot. It could be that your parent has a will, but you're just having a feeling that that something is wrong. So I'll give you scenarios that have had wills challenged, and then you can reason for yourself whether that's one of the scenarios that fits your bill. So one, wills get challenged if they have not been well executed. So if, for instance, the will has not been signed, then that's a ground for challenge, because anyone then would have prepared a document to purport it's a will, but it really does not reflect the wishes of the deceased or the testator. So that's a point where wills get challenged. Wills get challenged if they're just outrightly unfair. Well, mzee aliandika well vizuri, ali-execute kila kitu, ilikuwa witnessed, but it's unfair. The property was given to totally unrelated people other than the beneficiaries. They can always challenge that will and approach court under Section 26 of the laws of succession. Wills get challenged by saying the testator was unduly influenced. There are people who die at old age, have lost their faculties, have lost certain capacities, and they're unduly influenced to bequeath property to certain people. So if you have evidence or if you have suspicions that the testator was unduly influenced, that can be a ground to challenge the will. Wills are challenged based on testator not having capacity. Maybe at the time they were not in the right mind frame. They were very sick to have appreciated the process of making this will. Wills get challenged on that. Wills get challenged on the executor. Now, if the will was written and now there's an executor doing his own things outside that which has been stipulated in the will, or doing things that are not in the best interest of the beneficiaries, wills get challenged on that ground as well. Wills get challenged on executor not acting. So you have been appointed as an executor. It's 1 year down the line, you're not acting. You're not taking charge. Wills get challenged on that. Wills get challenged on intermeddling. There's a will, but there are certain beneficiaries already dealing with the property of the deceased outside what has been stipulated in the will. You can approach us to help you enforce that. So as always, we're very appreciative to gain audience from yourselves. Please hit the subscribe button, subscribe to our channel. You can suggest on topical issues that you want us to cover, and we'll be happy to do that. Thank you, and may God bless you. Cheers. We hope we've been useful.